Good afternoon. My name is Stephen Sachs, and I serve as the Antonin Scalia Professor of Law here at Harvard Law School. As such, it is my honor to introduce you, Judge Rachel Kovner of the United States District Court for the Eastern District of New York, to deliver the Justice Antonin Scalia Lecture. The Justice Antonin Scalia Lecture Series was established at Harvard Law School in 2013 by an anonymous donor to promote and advance understanding of the founding principles and core doctrines of the United States Constitution. Speakers are drawn from the fields of political science, history, philosophy, law, government, religion, and related disciplines. The person chosen to be the Scalia Lecturer is a scholar or figure of high distinction who, through their work, research, writings, and teaching, elucidates the principles of the American founding. And today we are fortunate to have with us to discuss these principles Judge Kovner, who was appointed to the Federal District Court in 2019. Before her nomination, she had served as an assistant to the Solicitor General, arguing a number of cases before the Supreme Court, 13 if I counted correctly. And she argued for the United States as amicus curiae in the personal jurisdiction case of Bristol-Myers Squibb versus Superior Court, which my civil procedure students will remember is rejecting the California sliding scale approach to jurisdiction, and also in the search and seizure case of High versus North Carolina, in which criminal procedure students may remember as holding that an officer's mistake of law may still be reasonable enough to count towards reasonable suspicion under the Fourth Amendment. Prior to her work in the Solicitor General's office, she was an assistant U.S. attorney in the Southern District of New York and a Temple Bar Scholar of the American Inns of Court. She was a law clerk in Justice Scalia's chambers during October term 2007. That was a very uneventful year with little-known cases such as Boudin v. Bush, Medellin v. Texas, and District of Columbia versus Heller. Previously, she had served as a law clerk to Judge Wilkinson of the U.S. Court of Appeals for the Fourth Circuit, had graduated from Stanford Law School and Harvard College, and was a fellow resident of Quincy House and fellow colleague on the Harvard Crimson. I am very glad to have Judge Kovner back on campus with us today. I'm grateful to her for accepting this invitation to speak, for all those who made this lecture possible, and to all of you for sharing your afternoons with us, and I look forward to her talk. Judge Kovner.
So thank you so much for having me. I am very honored to be giving this lecture named in honor of Justice Scalia, a legal giant and of course an alumnus of this law school. This lecture has a special significance for me because of the role that Justice Scalia played in my life as a lawyer. I had the great fortune, as Professor Sachs mentioned, to clerk for Justice Scalia, and it was a formative experience, not just in terms of learning about the law, but in terms of learning about how to be a lawyer, and for that matter, a judge. Justice Scalia had been on the court for more than 20 years at the point that I clerked for him, and all of us clerks were just a couple years out of law school. But if we had one reaction and he had another reaction on a case, he wanted to hash those issues out through argument, sometimes for hours. His commitment to reasoned debate was inspiring. Maybe a less widely known fact about Justice Scalia is that he was a mensch to work for. I never saw him lose his temper with someone in chambers, and the buck always stopped with him. I think of him often now that I'm a judge and have my own chambers. I was lucky to cross paths with Justice Scalia a second time in my career, as Professor Sachs mentioned, when I worked about 5 years later in the Office of the Solicitor General at the Department of Justice. And I got to argue some cases in front of Justice Scalia before he passed away. He was especially fun to appear in front of because he liked to mix it up with lawyers as much as he did with the clerks. In the first case I argued as a brand new advocate, I was defending a traffic stop based on an anonymous tip of reckless or drunken driving. Justice Scalia took the case as an opportunity to write a dissent in which he called my position a freedom-destroying cocktail. As a lawyer, it was a relief to have the justice on your side in a case, but somehow Justice Scalia made being on the other side entertaining too. Because this is the Scalia Lecture, I thought it might be appropriate to reflect on these two experiences in combination by talking about textualism, one of Justice Scalia's most enduring legal contributions, and both the role and the limits of that role that textualism plays on the Supreme Court today. After all, it was in a conversation on statutory interpretation as part of this lecture series that Justice Kagan famously declared, "We are all textualists now." What I'm curious about is, are we? or more precisely, is the Supreme Court a court of textualists now? Justice Kagan herself suggested in a recent dissent that she's not currently so convinced of the court's commitment to textualism after all. In exploring that question, let me say off the bat that textualism is certainly a dominant first-order methodology on the Supreme Court these days. It will be hard to argue otherwise. The argument I do want to offer, though, is that considerations of purpose also play an important role in the statutory interpretation decisions of the current Supreme Court. Specifically, while the court is loath to describe itself as reasoning from purpose, it does so in statutory interpretation cases not that infrequently, often under banners like context. Further, while textualists like Justice Scalia left some room for the use of purpose, the current court's use of purpose is not really confined to the narrow limits that fit with textualist critiques of so-called purposivism. So before developing these points a little bit, I want to back up and talk about the understanding of textualism that I'm operating from. Justice Scalia described textualists as those who look for meaning in the governing text and reject judicial speculation about both drafters' extra-textually derived purposes and the desirability of the fair reading's anticipated consequences. He and others often defined this philosophy in opposition to purposivism. Purposivism, in turn, was exemplified for Justice Scalia and some others by the Church of the Holy Trinity case, where the court famously identified a conflict between what it described as the letter of a statute and its spirit, and determined that, in the case of that conflict, the spirit should prevail. Textualists, of course, say the opposite. One reason is that textualists are skeptical about whether it makes sense for courts to infer a guiding purpose or spirit from a statute enacted by a multi-member body. These statutes are often the product of compromise between individuals with different and perhaps conflicting goals. Proponents may put forward a bill to serve one purpose, but others who are indispensable to its passage may insist on changes or limitations designed to serve entirely different purposes. Hence the saying that no statute pursues its purposes at all costs. Given this reality, textualists often caution that the words of the statute are the only reliable indicator of the actual bargain that the legislature made, and that abstracting an underlying purpose from the words can lead courts astray. Now, this is not to say that textualists have no room for anything described as purpose. Justice Scalia wrote that it's wrong to think textualism precludes consideration of a text purpose because, quote, the evident purpose of what a text seeks to achieve is an essential element of context that gives meaning to its words. Noting this point, some commentators have argued that because textualists don't entirely swear off purpose, the difference between textualism and purposivism today may be more semantic than substantive, or at least a matter of degree. Justice Scalia acknowledged that even the judges he regarded as purposivists commonly start their decisions by saying they begin with the statutory text, although Justice Scalia joked that they were saying this in the manner of somebody starting out on a very long voyage. If textualists are willing to look at purpose, and purposivists themselves start with the text, the argument goes, maybe at this point the differences between these theories is a matter of degree. I'd like to return to the question of whether at least some of the court's statutory interpretation decisions bear this out later in the talk. But for now, let me note that some textualists would resist this conclusion because they see the use of purpose that's permitted in textualism as very limited. For example, Justice Scalia wrote that, quote, purpose is to be gathered only from the text itself, consistent with the other aspects of its context, and never from extrinsic sources or an assumption about the legal drafter's desires. Beyond this, he added, the purpose must be defined precisely and not in a fashion that smuggles in the answer to the question before the decision maker. It must be described as concretely as possible, not abstractly, and except in the rare case of an obvious scrivener's error, purpose, even purpose as most narrowly defined, cannot be used to contradict text or supplement it. It was only because Justice Scalia defined the permissible use of purpose in this very limited way that he could say, on the one hand, that textualists do consider purpose, and on the other hand, that textualism is defined by exclusive reliance on the text. Professor or Dean or Provost Manning offered a similar view when responding to this argument I've just made, that the differences between textualism and purposivism are mostly differences of degree. He argued that When textualists are considering purpose, they're mostly looking to semantic cues like dictionary definitions and canons to come up with the most coherent account of a statute. In other words, they're focused on evidence that goes to the way a reasonable person would use language under the circumstances. In contrast, he suggests, purposivists are focused on, quote, the way a reasonable person would address the mischief being remedied, close quote. They therefore give priority to matters such as public knowledge of the mischief the lawmakers sought to address, the way competing interpretations of a discrete statutory provision fit with the policy reflected in the preamble or title or overall structure, and the way alternative readings of the statute fit with the policy expressed in similar statutes. Professor Manning describes the reasons why this policy context may not be a reliable guide to the meaning of the statute from the perspective of a textualist. Namely, he writes, statutes are seldom crafted to pursue a single goal, and compromises necessary to their enactment may require adopting means other than those that would most effectively pursue that main goal. Okay, so with that background about these interpretive strategies in mind, let me turn back to the question, is the Supreme Court a court of textualists now? Now, I've previewed that I'm not going to dispute that text is currently the first stop, and in many cases the only stop in statutory interpretation for the Supreme Court. So in that way, the answer is yes. But I'd like to argue through some examples that purpose-based reasoning also plays an important role in a variety of the court's statutory interpretation decisions, often coming in under the label of context or history. I'll leave it to you to decide whether these cases invoke purpose only after the text runs out. That's a topic that's debated by the court in each of these cases at some length, and these are in parts of the decisions that I'm going to bypass. And when I read the statutory text, you'll have your own view about that. Rather, the point that I intend to make today is that these uses of purpose are not limited to the types of purpose that Justice Scalia or Professor Manning described as compatible with textualism, which is gathered just from the text itself, without inferences about how a reasonable person would have wanted to address the mischief in question. Moreover, these uses of purpose cut across the ideological spectrum on the court. They're not simply reflective of the court having a textualist wing and a purposive wing. In that way, I would submit purposivism is not dead, and it coexists with textualism on the Supreme Court today. Let me start by discussing a Supreme Court case that I argued for the government, Speaker's prerogative. It's Mullooly versus Lynch. This is an ordinary meat and potatoes statutory case, and it concerns whether a conviction under a Kansas drug law made an alien removable from the United States. It involves a provision of the immigration laws that make removable an alien who has been, quote, convicted of a violation of ... any law or regulation of a state, the United States, or a foreign country relating to a controlled substance as defined under the federal drug laws. Now, Kansas is like most states in that it has its own drug schedules, which mostly track federal law, but not precisely. Kansas controlled 306 drugs in total, and 9 were not federally controlled. Put another way, 97% of Kansas's controlled substance were federally controlled and 3% were not. So the court had to determine, was an alien who violated Kansas drug law someone who would have violated a law of a state relating to a controlled substance as defined in federal law? The court answers this question no, in an opinion by Justice Ginsburg, joined by Justices Roberts and Scalia, among others, and over the dissent of Justices Thomas and Alito. This is before the most recent appointments to the Supreme Court. The court agrees that the question is whether the Kansas law, under which the alien was convicted, relates to a federally controlled substance. And the court agrees that the term relating to is broad. So why is a conviction under Kansas's law not a conviction under a law that relates to federally controlled substances when it reaches convictions involving hundreds of drugs that are controlled under federal law? The court's answer is what it calls context, specifically 2 features of the context. The first is historic. Congress and immigration authorities historically had required a link between a crime of conviction and a drug that's actually federally controlled. The second is a concern about the breadth of an alternative reading of relating to that would sweep in the Kansas statute. While Kansas's drug schedules very substantially overlapped with the federal ones, the court wrote that a statute with any overlap would seem to be related to federally controlled drugs. Indeed, maybe even offenses related to drug activity more generally, like drug possession, would qualify in an indirect way as related to federally controlled drugs. The court suggests that these broad potential applications mean the statutory language should be read narrowly, because reading the statute to reach crimes like gun possession, quote, departs so sharply from the statute's text and history that it cannot be considered a permissible reading. So a couple observations about this case. This decision never uses the word purpose to describe how it's construing the statute, but the considerations it's describing as about context and history are about implicit statutory purpose. The court is relying on an inference that the enactors of this provision had the purpose of continuing rather than disrupting what the court sees as historical practice of linking deportation only to convictions that inherently involve federally controlled drugs. The court's also relying on an inference about how Congress would sensibly have intended to reach as a substantive matter, including specifically about its preference for overbreadth or underbreadth. Under laws like Kansas's, many drug convictions will involve federally controlled substantive, but some will not. Would Congress have prioritized ensuring the removal of all aliens whose convictions under state law involve federally controlled drugs, in which case Kansas's conviction should count? Or would Congress have prioritized preventing the removal of aliens whose convictions involved exclusively state-controlled substances, in which case Kansas's conviction should not count? The text does not tell us, and the court's inferences about these questions are inferences, to use Professor Manning's framing, of the way a reasonable person would address the mischief being remedied. They're not, to use Justice Scalia's language, gathered only from the text itself. Let me jump forward to a statutory interpretation case decided just a year ago, Pulsifer versus United States, which has some interesting back and forth between the majority and dissent, which I'd submit are both actually using purpose. So purpose concerns language enacted in the, Pulsifer concerns language enacted in the First Step Act. The provision in question, known as the safety valve, allows some drug offenders to be sentenced below a mandatory minimum that would otherwise apply to them. And the First Step Act expands the availability of safety valve relief. The question in Pulsifer is basically about the size of that expansion. Specifically, the First Step Act makes a sentence below the mandatory minimum available only to a defendant who, quote, does not have, and then it gives a 3-item list. So it's A, more than 4 criminal history points, excluding any criminal history points resulting from a 1-point offense as determined under the sentencing guidelines, semicolon. B, a prior 3-point offense as determined under the sentencing guidelines, semicolon. And C, a prior 2-point violent offense as determined under the sentencing guidelines. The question is whether a defendant is disqualified from safety valve relief if he falls into any one of these 3 categories, or only if he falls into all 3 categories. The court holds that falling into any of these buckets is disqualifying. In an opinion by Justice Kagan that's joined by Justice Roberts, Kavanaugh, Barrett, Thomas, and Alito. The court says, as a textual matter, the language that I've just read to you is ambiguous, so one must examine what it describes as content or context. The court has one argument along these lines that is quite textual, involving whether the first provision I read to you, the A provision, would be superfluous on the defendant-friendly reading of the statute. But beyond this, the majority suggests that construing the statute requires looking to the substance of the 3 buckets to determine which reading would reflect a more sensible statutory design. Reading the statute to disqualify those who fall into any one of the buckets, the court says, quote, unerringly separates more serious prior offenders from less serious ones, allowing only the latter to get through the gate. In contrast, in the court's view, disqualifying only offenders with all 3 types of convictions, quote, allows and denies relief in ways that do not correspond to the gravity of what a defendant has previously done. I'm going to skip the details of the anomaly that the court uses to argue this point. It involves a situation where when the more defendant-friendly reading of the statute, a person with less serious criminal history would be ineligible, and the person with a more serious criminal history could still get safety valve relief. But invoking that example, the court concludes that the defendant-friendly construction, which denies safety valve relief only to people who fall into all 3 buckets, does not do a good job of separating less serious offenders from more serious offenders and should be rejected. So the court reaches this conclusion over the objection of Justice Gorsuch, who's joined by Justice Sotomayor and Jackson. Justice Gorsuch's main argument is textual, and he raises the objection you might expect to what he describes as the majority's, quote, purpose or, quote, policy argument about separating serious offenders from less serious ones. He suggests these considerations are off limits. But as the majority observes, Justice Gorsuch's opinion is not all about text. Justice Gorsuch begins his dissent with a recounting of the First Step Act as, quote, the most significant criminal justice reform bill in a generation, using a description that he takes from an amicus brief filed by a senator in a different case. He notes that the federal prison population grew in the 1980s and 90s due to mandatory minimums. And he says that in the First Step Act, Congress sought to recalibrate its approach by making changes to reduce prison populations, including changing the safety valve. And he emphasizes that the majority's reading of the statute will afford safety valve relief to fewer defendants than his reading. While Justice Gorsuch describes all of this as, quote, background, that, quote, helps in a way he doesn't precisely specify, a reader might draw the inference that this information is being offered to advance the view that the dissent's interpretation is superior because the thrust of the First Step Act was to make sentences more lenient. And so it is that the majority accuses the dissent of relying on a misguided argument about legislative purpose, while the dissent is accusing the majority of the same thing. For me, that's what makes this case especially interesting. Both the majority and the dissent seem to be considering purpose in some way, with the majority emphasizing an objective of accurately sorting less offenders from more serious ones, and the dissent emphasizing the objective of leniency. But neither side couches its own interpretation in the language of purpose. Instead, each side criticizes the other for invoking purpose when it should not. The last case I'll offer up from consideration as evidence of the court's approach to purpose and text is this past term's Fischer versus United States about the criminal liability of those who breached the Capitol on January 6th, thereby delaying the congressional proceeding to certify election results. By way of background, federal law imposes penalties on any person who interferes with official proceedings as set out in a two-part provision. One part, which is C1, is about documents and things like that. It makes it a crime to alter, destroy, mutilate, or conceal a record, document, or other object with the intent to impair its integrity or availability for use in an official proceeding. The next part, C2, imposes penalties on anyone who, quote, otherwise obstructs, influences, or impedes any official proceeding or attempts to do so. Fischer posed the question of whether a person who obstructed the congressional proceeding to certify the election could be convicted of violating the otherwise provision on that basis. And the alternative is that C2 is also document connected like C1 and reaches only those who impair the availability or integrity of records, documents, or objects used in official proceedings in ways other than those specifically mentioned in C1. The majority adopts the latter view. It reasons that the impairment of records, documents, or objects is required, in part because, quote, it makes sense to read subsection C2 as limited by C1 in light of the history of the provision. Specifically, the statute was enacted after the Enron scandal revealed what the court describes as a loophole in existing statutes. Those statutes made it a crime to corruptly persuade others to destroy documents, but not to actually destroy the documents. The court reasons, quote, it would be peculiar to conclude that in closing the Enron gap, Congress actually hid away, in Section C2, a catch-all provision that reaches far beyond the document shredding and similar scenarios that prompted the legislation in the first place. A further problem, in the court's view, is that the government's reading of C2 would impose severe penalties on conduct the court describes as not especially grave. In addition, it would impose serious penalties on types of obstruction that were already covered by other statutes for which Congress had set out more modest penalties. The court deems these results inconsistent with statutory context. As you probably guessed by now, I think it's fair to bill what's being described as context here as statutory purpose. And these don't seem to be inferences of purpose from text alone. For instance, the text does not seem to tell us whether a legislature confronting a huge, high-profile fraud would have wanted to pass robust additional penalties targeting all obstructive conduct, or narrower penalties targeting particular types of obstruction for which existing law seemed deficient in the particular context of the fraud that led to the bill. And given how common overlap is in the federal criminal code, the text alone does not seem to plausibly instruct the reader that these provisions were meant to be non-overlapping with other obstruction laws. These forms of reasoning seem more easily described as inferences about what a reasonable legislator would have thought or done when confronted with a particular problem, rather than inferences drawn only from the text. So let me step back and try a few general observations about how these cases do and do not match up with textualism and purposivism. While my focus has been on the use of purpose in these cases are consistent with the conclusion that, in substantial measure, textualism has carried the day on the Supreme Court. Virtually every statutory interpretation decision starts with an analysis of the text, as do all the ones that I've discussed. And the court routinely says that when the text is clear, its analysis ends there. Moreover, this triumph of textualism has brought with it explicit skepticism about the consideration of statutory purpose. As I think these cases illustrate, the court rarely describes its own reasoning in terms of purpose. Instead, it's turned to other labels like context and history when it's engaged in reasoning that could reasonably be described as purposive. When the term purpose is used, as in Pulsifer, it may well be to accuse a majority or dissent of considering something that should be off the table. I take that as a measure of how much sway the textualist critiques of purposivism have had on the Supreme Court. That said, I hope these cases show that purposive reasoning is playing a role on the court alongside textualism. And I respectfully submit in discussing these cases that at least sometimes we're not talking about purpose in the limited sense that Justice Scalia and folks like Professor Manning have accepted, in which purpose is very closely connected to the statutory text. Instead, in at least some of the cases I've discussed, the court seems to be inferring what a reasonable legislator would have done when faced with a particular problem. That type of reasoning is in some tension, as I mentioned earlier, with textualist critiques of purposivism, because of how textualists see legislation as reflecting compromise between individuals with many different goals rather than one readily ascertainable purpose. I also hope the cases I've discussed today provide some evidence that use of purpose is not limited to the group of justices who are sometimes called liberal, or for that matter, the group of justices who are sometimes called conservative. Each of the justices generally classified as conservative signed on to at least one of the opinions I've just discussed. For that matter, we see justices who are often described as liberal in some of these cases joining dissents that fall to the invocation of purpose on the theory that the text is clear. I mentioned at the outset that some scholars take the view that now that some of the main arguments advanced by textualism have taken hold as broadly as they have, the remaining distinctions between textualism and purposivism are a bit overblown, because textualists look to purpose when text runs out, and purposivists agree that text is the best place to find purpose. To me, the cases that I've discussed today provide some support for this view by displaying some fluidity between textualist and purposivist approaches on the court. In at least some cases, your justices across the spectrum deploy both types of arguments. If textualism has triumphed on the Supreme Court, as Justice Kagan suggested, I submit that purposivism is not dead yet and continues to play a role there too. Assuming that I talked fast, which I usually do, then we can do questions.
So I think what you said is right. I'm curious about how you think about whether Justice Scalia is also guilty sounds a little bit, but whether his approach really is different from the one that you're describing the current court using. So it seems to me that that distinction depends on this idea of a purpose derived entirely from the text. I'm not sure there is such a thing. So let me give you one of these examples, as I recall it. In reading law, he has this discussion of the no vehicles in the car case, and he says, well, look, vehicle, technically, it's in the dictionary, there's like conveyance, you drive or whatever, which is usually what people are debating about, but there's also like mixing media for, like in chemistry, it's a vehicle for delivering like whatever to a thing. And he says, so it could be that, but, and this is like the approved use of purpose, like, why would you ban that from parks? Like, there's as much reason to ban that from parks as elephants from parks. Okay, seems to me that is not a purpose derived from the text. That's a claim about purpose of the kind I think we're talking about. It's not derived from the text, it's derived from certain premises about what social problem the legislature was probably trying. How does he know that the legislature doesn't want to ban chemistry from parks? Unless he knows that there was or wasn't a lot of chemistry happening in parks, which seems like a worldly policy concept. And maybe it only happens once in a while, but we really want to ban it. So all of this seems to me not derived from the text, and I guess I wonder if the distinction, as illustrated by that case, just breaks down to the point that the category you need to limit these views is kind of an empty one.
Yeah, I think that's a fair point. I mean, when I read that part of reading law, and the assertion is that there is nothing aside from text that is going on in the no vehicles in the park inferences, I guess, I think it's a bit of an overstatement. I'm not sure that means that there's like nothing to this idea that there's a purpose that comes more from text versus a purpose that is really what would I do as a legislator. Pulsifer, to me, is actually pretty close to purpose that comes from text. Like, the statute is expressly incorporating the sentencing guidelines as a measure of the severity of offenses, and so to say, it is odd that on this view, what the sentencing guidelines have called sort of a more severe offender would be treated more favorably than less. That argument, there might be some premises that are outside of the text, but it's pretty closely connected to the text. There's not a lot of what would a legislator do that's going on there. Some of these other examples, I think there's a lot of what would a reasonable legislator do. So yeah, maybe there's always some knowledge about what is some common sense inferences that are going on. I'm not sure that means the distinction is without a difference. Part of the reason Justice Scalia is such a great writer is that he's emphatic and sort of rules-based.
I'm wondering how much of the tension we can get rid of if we sort of think of it as not what a reasonable legislator would do, but rather what a reasonable person reading the statute would think the purpose was. So I'm an individual, I exist in context, and I understand that legislators are trying to do particular things, and when I read that statute, I bring to bear that experience to it. So do you think we can sort of resolve some of the tension if we put ourselves in the shoes of the reader of the law and rather than the legislator?
Yeah, I think that resolves maybe a separate tension, or definitely a tension that textualists talk about, which is like the thing that is actually a law is the statute, and so what we care about is more like what its public meaning would be than what the legislator was thinking. If the legislator was thinking something idiosyncratic, but the law has a particular meaning, we think that the statutory meaning is the law. I guess I'm not sure it solves the problem of like how does a judge ascertain the answer to this question? Like, I think part of the textualist thought is when there are policy problems, it's like the weighing of these conflicting goals. It's very hard to get out of the text. Like, it's a contestable, question how you should answer in an immigration context, who you want to remove in a criminal justice context, who you want to subject to enhanced penalties, and we want to do what the legislature actually enacted about that as our democratic representatives. And it may be that the textualist view would be looking at the words is the best we can do to figure out what they actually enacted about that, and answering the question, what would a reasonable person think, is just kind of a hard and speculative question, I think, is part of the difficulty.
This relates a little bit to Professor Adams' question, but I'm wondering, do you take yourself to be telling a sort of, not quite timeless, but like decades-long story, or is this a more recent development? Because you mentioned Justice Kagan's remark, or like recent skepticism about whether, in fact, the justices are committed to textualism. Then I took it to reflect, in her views, of change in approach, right? A sort of convenient, recent shift away from a more strict version of textualism. So I'm just curious, do you think this is a more recent trend, or is it something that, going back to Professor Adams' point, something that's been going on really since the entrenchment of textualism?
Yeah, I mean, so I think there is some, like, people debate whether how widespread like a strong purposivist approach was even like before textualism. Like there is the Church of the Holy Trinity case. I think there are people who would say, okay, but actually the court has often said or always said for a long time that like clear text is something we're going to enforce, so that textualism isn't like totally changing the trajectory of the law in that respect. I guess I am talking about a recent period in which it seems like there's a lot of buy-in into textualism. I'm not sure I'm speaking to an earlier time and how much change there's been since then. I guess my anecdotal impression would be there were justices on the court up to fairly recently who were more comfortable with purposivism and more just willing to be open about that. I mean, I think Justice Breyer would say courts should take into account purpose more than the current court does. And now it seems like recent Supreme Court opinions, there's sort of more consensus about just kind of some of the rules of textualism as a methodology, which is, I guess, what it makes it interesting for me that purpose is still being used, I think.
So this might be a little bit 2 steps removed from the talk, but it's definitely related to Eliza's question, at least. And that's, it seems like if we care about ordinary public meaning, it seems like one person's judge of that is not a very good metric for ordinary public meaning. It seems like the only way you could really, in some sense, calculate ordinary public meaning would be using something like an AI or a large language model. So I'm curious if, this is a little bit removed, so I apologize, but if you think that the end game of textualism should be an AI interpreter.
It's an interesting idea. I mean, I guess there are some tools that textualists try to use that are not just, I look at the text and here's what I see, right? So the kind of reading law project is, let's kind of set out some rules, which are the rules that we think reflect how we actually interpret texts, or at least now we know what they are. We'll know what they are when drafting them. They'll be sort of ground rules that we can neutrally apply to interpreting text. Whether AI would be better, I mean, I'm not sure we know that yet. There are like kind of these tools short of AI, like a corpus linguistics tool. I guess the benefit of something like that as compared to like asking ChatGPT, what does this mean, is you sort of know what's going on in the model. So it can tell you something like when the word, when this phrase is used, what's the context in which it's most frequently being used. It seems like, I don't know, potentially useful information. And maybe as AI gets more sophisticated, you'll be able to do that, and you'll be able to see the work in a way that I'm not sure you can right now if you just ask ChatGPT to answer your question. But I don't know. Have you tried it?
I think that the current public AI models are not geared towards statutory interpretation,
Yeah.
But I think there's a startup out there waiting to happen.
Yeah.
Do you think that originalism has, to some extent, played a role in the leading period of textualism, with its emphasis on history and tradition, even originalism 2.0 that focuses ostensibly on ordinary public meaning? Do you think that emphasis on background context is, to some extent, eroding the sanctity of textualism?
I don't know. I mean, I guess what I've been suggesting about when the court uses the term history in some of these cases is there are a lot of contestable judgments involving the way that it's using the history. Did Congress want to continue or not continue that history? When the court's using history in the context of originalism, I think it's more looking to just trying to figure out what these words meant at the time that they were enacted. It seems like a different kind of use, so I'm not sure that saying, I don't know, what, either just like how was this word used at that time, or what were the historical practices surrounding the use at that time, and what can they tell us about how these words were understood. I'm not sure it's quite the same, so I'm not sure it's the use of one sort of signals that you're going to do the other potentially more objectionable thing. Yeah.
Back when I was in law school a long time ago, contracts was taught essentially as a person selling a shovel to somebody else. Money would change hands, the shovel would change hands, and they'd get to it. That law changed over time as contracts became much longer in term. And the courts recognized that the parties couldn't anticipate things that would be relevant to the deal because you can't predict the future. And now relational contracts is sort of an accepted way of interpreting relationships that are long-term. If you think about long-term, of course, the Constitution is an extreme example. And it's come, that notion of relational interpretation, it seems to me, is equally applicable to the Constitution. We've seen it in a number of cases. It is a wiretap search. Certainly the drafters had no clue about that because there's no such thing as a wiretap. But they still had to decide the case. Why can't one apply the same reasoning to a weapon that can kill 100 people in a minute and a half? There was no, you can't plausibly claim that the people who wrote the Second Amendment thought one way or the other about such a weapon, just like they couldn't think about a wiretap. So aren't we forced to say, as the world presents things that the drafters couldn't have imagined, we have to extend it in a way that we think is right? We do that in speech, of course, all the time. Is having a plane have a message over across the sky. Speech, they weren't thinking about planes because there weren't any planes. So this is absolutely routine in constitutional law, except when you don't want to go a particular way, and then it's forbidden. Am I missing something, or is it the same problem and we should have the same solution?
Well, I guess I'm not sure I would say the Supreme Court is like entirely consistent in its approach to interpreting every constitutional provision. So it may well be that sometimes it's more expansive about saying we face a new problem and we're going to be creative about how we address it. I mean, I think everybody would agree there's some kind of translation that's going on. So if you have a gun that fires 1 million bullets a minute, you have to consider how that fits under the Second Amendment or any other provision you're considering. And you're going to look at, a textualist would look at the language of the provision and see how does that fit within the language. I think your kind of alternative approach you're advocating is either this is a new problem that they didn't think about, and so we have to kind of figure out a reasonable answer to that problem. And I think a textualist or originalist would be concerned about whether the Supreme Court is the entity to do that, sort of answering in the first instance of sort of coming up with a sensible rule and saying it's the constitutional rule because it's sensible. I think that's something originalists are generally skeptical of, but it's a little bit beyond what I've been discussing, which is more about statutory interpretation, where of course the ability of the legislature to come in and say, hey, we've got this new problem is greater than the constitutional context.
Thank you for your thoughtful comments, which I think bring out two strains within textualism. One set of justifications for textualism and applications being with regard to textualism as the best way of getting at legislative intent with respect to compromises, the impossibility of using extra textual materials. And in this way, it's perhaps more compatible with finding yourself on a scale between text and purpose. And the second set of justifications, which Elias brought up a little bit, and which I see like Justice Gorsuch is maybe the best vindicator of, is like textualism as sort of a defender of the public's ability to read the laws, to stick to the laws by which they're governed. And I'm curious if you see this distinction being, one, useful, and two, likely to be like ventilated in further debates over textualism with respect to whether the judiciary sees itself as the faithful agent of the legislative intent, or as more of a faithful agent and defender of the public that is subject to regulation.
Yeah, that's an interesting thought. I mean, I think those two things, those two like rationales for textualism point in the same direction, I think, right? Because if part of the critique that's based on legislative compromise is like, how do we really know what the nature of the legislative bargain was aside from the text? It sort of also goes to the public knowledge point, right? Like, how is the public going to assess what the court would say, oh, here's the reasonable solution, or here's what we think a reasonable legislature would have done in these circumstances? I think those two rationales point in the same direction, but I guess I wish the court would explore more expressly when it's engaged in this type of reasoning what it thinks the rationale is, why it thinks it's permissible in the cases where it does it. I think that would be interesting because these are all careful thinkers. I think it would be interesting to say, you know, here's why I think that's compatible with critiques of textualism. Yeah.
So I think the empirical point here is really interesting because the idea that currently there's some purposivism hidden within our textual practice. And I wonder what normative point might follow from that. And I think it comes down to maybe one of two possibilities. One, that we should readily acknowledge that purposivism is a part of our law, a small part, but when we're doing it, we should discuss it honestly. Or alternatively, we might think that we should maintain a fiction where we only do purposivism to the extent that we're able to colorably, if not definitively, argue that it is actually textualism. So essentially, to restrain purposivism's danger, we do it only to the extent that we can make it seem like we're not doing it. Like, does either of those seem like a normatively compelling path forward?
I guess I never thought about the idea that it's like constraint on the use of purposivism, that we sort of say we're not doing it, and so it means we're only going to do it in limited circumstances. I've never thought about that. I guess my sort of baseline first principle is that it's helpful for judges to say what they're doing. That's like the best way to get good decisions, and that like everybody's decision making is refined by here's what I think the statute is, here's why I think that, and somebody else can come back and say why that's wrong. So I guess my baseline preference is for maximal candor, and I guess I sort of am kind of interested in raising the question of like, okay, is there some purposivism that's going on, and like what's the takeaway from that? Is it that those are mistakes, or is it that actually there's some consensus around use of purposivism in some circumstances? And then I'd be curious to know if we can come up with rules for when we think it's permissible and when we think it's not. And I guess if what we do instead is just describe it in a different way, it maybe cuts off that debate. I've totally like punted on the question of like, is there any rationale for this? Is it good? Is it bad? Because those are really hard questions. I've sort of gone for the minimal point, just that it seems like it's happening.
What do extra-textual developments like the major questions doctrine or the history and tradition inquiry mean for the continued relevance and also intellectual consistency of textualism, especially when judges who are avowed textualists mobilize these kinds of doctrinal moves in their opinions?
Yeah, so I mean, I think major questions is the context in which Justice Kagan said, now I'm, hey, wait a minute, I thought we were textualists, and now it seems like we're creating a rule that's actually sort of smuggling in some purposivism, some kind of reasoning about what we think Congress would have wanted. So there's a critique of the major questions doctrine that Justice Kagan is offering that is basically along these lines, that it's not consistent with textualism, and that's a big debate. And so instead I've chosen these more palatable or smaller statutory interpretation cases to illustrate the point. History and tradition I think of as trying to be a way of getting at what a text meant, sort of given the problem of a text that was enacted a really long time ago. How do we figure out its meaning? So I guess you could dispute whether it's a good tool for that. I think that's what it's trying to do. So I think of it as an attempt at kind of filling out textual meaning. Yeah.
To what Professor Adelson said earlier, can we say that we know that vehicles can't have that chemical meaning because of common sense? And
well,
so,
I think...
and so in that way, can you say, just as the court is sometimes saying context is the beginning purpose, are they using common sense in that same way? And to the major questions doctrine point, Justice Barrett would respond to Justice Kagan and say, no, this is just context plus common sense, and that's consistent with textualism.
People definitely would say it's common sense. I think the problem is that's just a species of, like, what would a reasonable person think? I'm not sure that it's different from that, right? It's like any reasonable person would know what we're talking about when we're talking about vehicles in the park because of what a reasonable person knows about what poses a danger in parks, and so what somebody would have wanted to make a rule about. I guess, do you think there's a sharp distinction between common sense and like what a reasonable person would think? Yeah, yeah. Yeah.
Yeah, so it's kind of like a direct follow-up to that. So first, thank you for the talk. One thing that came out of it for me is that there might be two strains of purposivist thinking. that are kind of embedded, sometimes kind of explicitly in this textualist rhetoric of the court. One is a kind of like legal processy view, which is a little bit like the passage that Professor Addison quoted from Scalia, where exactly like you were saying just now, the inference is not about what an actual legislator thought, but an idealized version, like a reasonable legislature would have thought. As opposed to something like the Gorsuch dissent that you mentioned, where I think what the business of going into, some of the history was to figure out what the actual legislature might have thought without any judgment about whether it was reasonable for them to think that way or not. And, I mean, one thing that I'm wondering now is whether you see one of these two strands as being more dominant than the other, just as a sort of like descriptive matter in Supreme Court jurisprudence today.
I mean, I guess the area that goes to like what the legislature actually thought that is different from like the question of what a reasonable person would have thought is like the legislative history bucket, I think. Otherwise, I think there's probably some overlap between what we think the legislature was probably trying to do and what a reasonable person would have done. I mean, I guess, in terms of so it's sort of like the looking at extrinsic materials versus inferences of purpose. I guess you're right, there are two kinds of questions you could engage in there, and sort of textualists are skeptical of both, right? Does that answer your question? Yeah. All right. Well, thank you so much for having me.